Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about a case that was just heard at the Supreme Court of Canada about whether or not Canadians have a constitutional right to travel within Canada. Section 6 of the Charter protects the right to what's called interprovincial mobility, the right to enter, remain in, and leave Canada, and to move and to take up residence in any province. But during the COVID-19 pandemic, the province of Newfoundland and Labrador took the bizarre position that there is no right to simply travel between provinces. That province was sued after it initially refused entry to a woman named Kim Taylor from Nova Scotia who wanted to travel to Newfoundland to attend her mother's funeral in May of 2020. Miss Taylor, supported by the Canadian Civil Liberties Association, argued that she had a right to enter the province of Newfoundland under the Charter. The question about the source and scope of the right to move around within Canada is now being considered by the Supreme Court. And the charity that I work for, the Canadian Constitution Foundation, intervened in the case to argue that there is such a right, not just in the Charter, but also informed by other parts of Canada's Constitution. The CCF was represented in that case by Jessica Kuredjian and Hardeep Dhaliwal of Cassels, and we're joined by both of them today to discuss the case. Thank you both so much for joining me today. Let's start by talking about the facts of the case. Hardeep, I explained a little bit about what happened to Miss Taylor. What can you add there?
Yeah, so to provide a bit more context, during the pandemic, Newfoundland and Labrador issued a special measures order. And under that order, all individuals were banned from entering the province unless they lived there. As you mentioned, Miss Taylor applied for a exception to that rule. That rule was if there's extenuating circumstances, you could be let in. She was denied entry, and then she did apply for reconsideration. And at that point, she was let in. Again, I think you already mentioned this, but it's that first refusal that's at the heart of this case.
So, Jess, Section 6 of the Charter protects the right to what is called mobility. Can you tell us what the provision says and why it's at issue in this case?
For sure. So, Christine, broadly speaking, Section 6 of the Canadian Charter of Rights and Freedoms, it contains provisions that protect the right of Canadians to move freely, or so we thought, and work throughout the country while balancing provincial regulations and social programs. Now, for the purposes of the Taylor case, there are two sections that are of relevance. So, the first section, is called Mobility of Citizens. And that's section 6.1, which says that every citizen of Canada has the right to enter, remain in, and leave Canada. And now section 6.2, or rather 6.2, so that the heading over that section, if you will, is rights to move and gain livelihood. And for the purposes of the Taylor case, we're really concerned with section 6.2a, and 6.2a is the right to move and take up residence in any province. And 6.2a applies not only to Canadian citizens, but permanent residents.
So, I mean, it's just so strange to me the position that Newfoundland's taken that, there's a right guaranteed to relocate to another province or to move for work, but not to simply cross the border for, in this Taylor's case, a funeral. I mean, it just seems a strange interpretation. At core in that idea is this notion of something called mobility simpliciter. So, Hardeep, maybe you can explain what that is and why it's relevant in this case.
Yeah, so the idea of mobility simpliciter, it basically refers to the basic unqualified right of someone to move freely within the country. This is important in this case because the Newfoundland and Labrador are taking the position that 6.2 of the charter doesn't protect this general right to move between provinces. Rather, it only protects the right to go to another province if you're either going to go there to work or to take up residence there.
Yeah, it's such a strange interpretation. I think that at the core of the argument, there's a debate actually that's really interesting to get into, and we'll get into this in the next segment about the English versus the French version of the charter, because the language in the French charter makes it a little more clear that we're not just talking about moving as in relocating, but moving as in roaming around. And I think that that was core to the argument in Miss Taylor's case. We'll talk about that in the next segment. We will be right back. Welcome back to Canadian Justice, where we're discussing a case that was recently heard by the Supreme Court of Canada about whether or not you have a right, a constitutional right, to cross provincial borders. Now, the province of Newfoundland, Jess, had taken this strange position that the charter protects the right to cross a provincial border for the purposes of relocating or the purposes of employment, but not this idea of you just want to cross the border. In Miss Taylor's case, it was to attend her mother's funeral during the pandemic. And core to the argument that the Canadian Civil Liberties Association made in this case was this debate over the French text of the charter. Can you explain that argument to me, Jess?
Sure. So, Christine, you really just touched on one of my worst professional fears, which is that at some point, somewhere, somebody would ask me to pronounce French words, and in this case, on television. So, I want to thank you for that. Moving forward, I'll remember that, but let's move forward. The Canadian Civil Liberties Association argued that the direct translation of the French text of Section 6.2a of the Charter, which I just discussed before the break, uses the word se déplacer, which means to move in the sense of to get around or to travel, and that therefore the true intention of Section 6.2a means or was to encompass the right to interprovincial travel. This argument actually does make a lot of sense because there's a separate word in French. The separate word, and here I go again, is déménager, and that encompasses the concept of actually moving in the sense of changing residence, whereas in English, we only have the word move.
Yeah, I mean, I actually think you did a great job with the pronunciation, much better than I would have done. So I'm happy that you are the one who said it, not me. Now, Hardeep, how does the court reconcile a difference or ambiguity between the French and English versions of the charter? And what stood out to me at the Supreme Court hearing was one of the lawyers making the argument kept referring to the French version as a French translation, and the court actually corrected counsel and said it's not a translation. Both are separate and equally authoritative versions. So, in that sense, how do you reconcile if there is a difference between the two?
So, if there's a difference between the two that cannot be reconciled, then the court will adopt the meaning that is most consistent with the purpose of the charter and that specific provision. Now, if one version is ambiguous, but the other version is plain and not ambiguous, then the court will adopt the version that is plain and not ambiguous.
And in this case, I think that the French version of the charter is a lot less ambiguous because it has this much more specific word. Now, just maybe you can tell me a little bit about what the lower court said in this case about whether there is a right to mobility simpliciter to travel between provinces and whether or not Miss Taylor, in this case, had a right to enter Newfoundland to go to her mother's funeral.
Sure. So what happened was the lower court found that under Section 6.1 of the Charter, Ms. Taylor did in fact have the charter right to travel across provincial boundaries for a funeral, but not the right to do it under Section 6.2a. And in coming to that conclusion, the judge found that the mobility rights in Section 6.2a related solely or 6.2 generally to the right to move and live anywhere in Canada to earn a livelihood in any province.
And there's this idea of six one, I think, said you have a right to enter, remain in, and leave Canada. And there was this notion, this analogy that the lower court judge gave about when you remain in your house, and if Canada's one house, you can remain in the house, but you can move to different rooms within the house, and the provinces are the different rooms. Now, Hardeep, the Court of Appeal in Newfoundland found that the case was moot. I mean, ultimately, Ms. Taylor was allowed into the province, and the pandemic is over. So why did the Supreme Court decide to hear it?
Even if the pandemic is over, this case raises a very important issue, which is, do Canadians have a charter right to interprovincial travel, the right to move freely within the country? There's no jurisprudence on this. There's no clear-cut answer, and that's why it's important for the Supreme Court to weigh in on this so we can get that answer.
Yeah, I mean, it's such an important part of a our constitution that has been not really considered before. I just don't think it had ever occurred to people before that there might be something like this happen, that a province would create a barrier like this. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the case of Taylor and Newfoundland that considers the right to travel within Canada and whether you have a right to cross a provincial boundary. The CCF was an intervener in that case. Jess and Hardeep, you represented the CCF. Let's discuss what you argued. I mean, your argument essentially is that there is a right in the Charter in Section 6. And we know this not just based on the text of the Charter itself, but also based on how other provisions of Canada's Constitution inform the Charter. What can you tell me about that, Jess?
Sure. So, in terms of, I'm not going to get hugely into the specifics, but what we said was a proper interpretation requires considering the context of everything as a whole in our Constitution and how those rights and laws, if you will, function together in harmony. And that when you read it as a whole, it's very clear that the framers of the Canadian Constitution intended to create a confederation whereby citizens, permanent residents of Canada had the right to interprovincial travel, both for travel and tourism, to work, participate in the electoral process, etc. And without again going into specifics, some of the charter rights, for example, we looked at were things that like the annual required sitting of Parliament, the charter right to seek remedies in court. When we look at the Constitution Act, we look at things like the postal service, we look at things like the military, and then, for example, we look at things like my favorite method of transportation, the ferries, which are federally regulated.
Yeah, I mean, if you have a right to seek a remedy from the Supreme Court of Canada, which sits in Ottawa, but you don't have a right to go to Ottawa, how do you actually exercise that other charter protected right? I think you have to read all of these provisions in harmony with one another. Hardeep, is there anything you want to add on that argument?
Yeah, and we to support that argument, we also looked at the charter debates surrounding Section 6 of the charter. So when we looked at those debates, it really showed that Section 6 was intended to guarantee travel. Members of Parliament emphasized that the purpose of the section was to ensure that every Canadian, regardless of whatever province they lived in, had the freedom to move freely within the country and to enter and exit a province at will.
And, Jess, if Canadians didn't have the right to interprovincial travel, to move within our country, if our country is one house and the provinces are different rooms, and you actually couldn't go into these different parts of your house, what would that tell us about national unity as a country, or even the existence of a single unified country? And does our Constitution inform that understanding in any way?
Well, Christine, I think it would tell us that something we always took for granted as a right or a protected right is not actually a right at all, and just something we've been taking for granted since Confederation. And we aren't, in essence, the single unified country that we thought we were. And to the extent that the right doesn't exist, or the court says, no, there is no charter protected right to this, it will create an interesting situation. For example, it would mean that if I were to fly from Toronto to Halifax, I could in fact be subject to entry requirements. But if I were to fly from Toronto, for example, to London, England, and then fly from London to Halifax, as a Canadian citizen, I would have a constitutionally protected right or charter protected right to enter Halifax. So it would just create a very bizarre situation.
It certainly would. It's interesting you raise this idea of dating back to Confederation because there was actually a question from Justice Rowe at the Supreme Court about not just pre Confederation, but ancient English common law and what he described as the rights of an Englishman to roam around the country. Hardeep, can you explain what Justice Rowe was asking about and if it is relevant in this case?
Yes, absolutely. It's relevant. Justice Rowe's reference to the rights of an Englishman to roam freely within his country shows that this idea of movement has deep roots in the common law. It reinforces the idea that you have the mobility to move within one's country. It isn't just this modern concept that's being brought up today, it's a long recognized right.
Yeah, and of course, the charter has another provision that guarantees that nothing in the charter is intended to abrogate or derogate from pre-charter rights. And I think that that's an important principle at play here as well, which Justice Rowe also brought up. We have to go to commercial break now, but we will be right back. Welcome back to Canadian Justice, where we're discussing a case about the charter right to travel between provinces and whether or not that right was violated in a case from the COVID era, where a woman named Kim Taylor was prohibited from entering the province of Newfoundland to go to her mother's funeral. Now, part of the issue in that case was whether the right exists at all. I think that's the big battle in this Taylor case is where the right to mobility comes from, if it exists at all. But another issue, one that the CCF, who intervened in this case, didn't take a position on, is whether or not this limit on Miss Taylor's right could be limited. The charter allows governments to impose reasonable limits on rights in Section 1 of the charter. So, Hardeep, can you explain maybe how that was a part of the case and what some of the arguments were, how the limitations clause works here?
Yes. So, like you said, all charter rights can be limited under Section 1 as long as that limit is reasonable and justified in a free and democratic society. So even if the special measures order, it's found if it infringed Section 6, Ms. Taylor's right to enter the province, the court may still uphold that legislation. And to decide that, the court uses what's called the Oakes test, and it looks at whether the government's goal within the legislation is important, whether the legislation is proportional, and whether it limits the right as little as possible. So I think in this case, again, the CCF didn't take a position on this, and it wasn't a battleground whether the law should be struck down. It wasn't a justified right under Section 1, but we will see if the Supreme Court of Canada makes a different finding.
Now, Jess, even if the court ultimately finds that the limit in this case was justified, I think it was still so important for this case to go forward to determine the source and scope of our mobility rights in Canada. What do you think?
Yeah, that's 100% right, Christine. That's why I don't like the sort of mootness arguments that were led that are sort of, well, who cares? It's over now. But the reality is, it is something maybe we've always taken for granted, but no court in the country has ever addressed this question. And to the extent that the charter language is ambiguous, then we do absolutely need the Supreme Court of Canada to provide its opinion and guidance so that we know what to do in the future. To that end, I really hope we don't find ourselves facing another pandemic in our lifetime. But I don't know what I'd do if we do, but if some sort of emergency arises, even if there is no emergency, the court needs to say, this is what this section means, and this is how to interpret it. And in my opinion, of course, Canadians and permanent residents have a right to interprovincial travel simpliciter. But we simply need the courts to come down and explain this because clearly the charter language is ambiguous, and it's so ambiguous that it has created a situation where I think we had no fewer than 12 lawyers at the Supreme Court of Canada for 2 days in front of these esteemed judges debating this very issue.
Yeah, I mean, I couldn't agree with you more about the mootness arguments. It's always in emergencies that governments try to expand their authority, expand their powers, test out new things. And emergencies, by their very nature, are temporary, they're short lived. So if governments can expand their powers during emergency powers and then retain those sort of new interpretations of the law and evade judicial scrutiny because they say, oh, the case is moot, the emergency's over, then we're left with a very dire situation for civil liberties indeed. Jess, just very briefly, there were a number of other governments that intervened in this case, but not all of them agreed with the position of Newfoundland. Can you tell me just briefly who took exception to Newfoundland's argument?
So quite shockingly, another East Coast province, PEI did not agree. They sided with the CCLA's argument that we talked about the French interpretation. And more importantly, they discussed how important national unity is and
Mhm.
interprovincial to PEI.
Well, Hardeep, Jess, thank you so much for your advocacy on this case. It's a really fascinating one.
Thanks, Christine.
Christine.
We've heard today about the story of Kim Taylor, who was initially prevented from entering Newfoundland to attend her mother's funeral during the COVID-19 pandemic. Do we have the right to travel within Canada? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.